Welcome. I am Dr. Patrice Berry, licensed clinical psychologist, and today is a bit of a pop-up live. I saw this case happening right now, and we are going to react to some of the testimony from yesterday and then also some of the testimony that's currently happening. And I'm not sure if the judge is going to come to his decision today, but I definitely wanted to talk about this a little more. And I think it answers some of those questions about residential treatment facilities. Thank you so much for anyone that's able to join live. Let me know if y'all have questions in the comments, and we are going to dive right into this case. So I remember hearing about the Slenderman case because everybody was concerned about were there these videos on YouTube, especially after this incident happened, where two friends. They were both 12 years old. They attacked another friend during a sleepover. Thankfully, she survived. And I'm not sure how she feels about the potential that one of her attackers may be able to have conditional release. Like I said, the judge has not made his decision on this yet, but that is what is currently happening. And the part I hopped in at was where the defense was kind of laying out their case. So I'm going to take a step back to the prosecution. But before we get there, let's just do a brief overview of this case. So, back in 2014, there was an attack that happened with a knife. There is a trigger warning for this case because she is now 21 years old. And after the death of her father, she came out and alleged SA against her father. And so I just wanted to give that heads up. That is going to come up. And then also, she's had a few attempts to unalive herself while she has been in treatment. And that is going to come up during this hearing as well. So that's just a heads up. And the friend was stabbed over 19 times. And like I said, it really is like the fact that she survived. And she still carries, I'm sure, a lot of emotions, a lot of distress related to this attack that happened by friends. And so let's hop into some of the testimony that's happened. So this was from yesterday. So this hearing started yesterday and it's continued into today. And the state is presenting its experts that are going to say that she's not ready for conditional release. And then the defense has mental health experts that believe that a step down to a group home is what's best for her right now. So I'm going to play a little bit of this expert's testimony. She is starting with just how long, like when she first started working with Morgan.
And when did that occur?
That occurred within a couple of days following the arrest, the index offense in this case.
And that, was May 31st of 2014.
Yes,
So within a few days of that, you were retained.
yes,
And do you recall when you first met Morgan Geyser?
June 4th of 2014.
And where did that occur?
That occurred at the Washington County Juvenile Detention Center.
Can you describe for the court as much as you recall about your initial impressions of Morgan when you first met her?
My initial impressions included that Ms. Geyser was not well psychiatrically, that she had experienced trauma, certainly in the commission of the offenses, and that she also presented as quite odd during the 2.5-hour interview I had with her. So her mannerisms were odd, her expressed emotions were inconsistent, sort of incongruous to what had occurred. At one point, she burst into tears when the threat of her Harry Potter friends not being present to her coming back was broached.
What did you think when you first met her?
When I first met her, I was collecting data, if you will. I was observing her, talking with her, obtaining information. I wasn't immediately forming conclusions or opinions.
And you've met with Morgan many times over the course of the years, true?
Approximately.
So this is a great question, and I do think that she did present. I think odd it is an accurate description. What she was doing, I in preparing for this, I looked at some things on court TV, and during her interrogation, and she's covered with her friend's blood, and she's like dancing around. They're asking her if she has remorse, and her emotions, they did not seem to match what she was talking about. And it seems like she may have a diagnosis of schizophrenia. It sounds like her father might have had that diagnosis as well. And they are going to talk about a diagnosis of PTSD, and but it sounds like she may have been experiencing psychosis. And so let's keep going.
Approximately a dozen.
Okay, and you've authored 7 reports to my count regarding Morgan.
Yes,
And I think we discussed this, but it really wasn't until the first petition for conditional release that you were court appointed. Is that right?
correct. I believe that's accurate.
All of that time being involved with Morgan prior to that first petition for release was as a result of being retained by the defense.
Yes,
Pause. I'm going to fast forward.
Usual at all in your experience throughout your career to have had that much contact with someone?
over that span of time, almost 10 years, yes, I would say that's unique. It's not singular, but it's certainly unique.
There have been other cases that you've been involved for this similar length of time and perhaps had that much contact with someone?
There have been cases where I've been involved for that length of time, okay, but not necessarily as many contacts for so many different reasons over time.
And in this case, you did conduct a review of mental responsibility with Morgan, is that right?
Previously?
Yes.
Yes,
All right, so I'm going to fast forward just a little bit so we get into more of the meat of everything.
I have to check my notes to confirm the accuracy of that memory.
And that would have been the psychiatrist at Winnebago?
Yes,
So sometime in the summer of 23, you're again contacted and asked to do a evaluation regarding conditional release.
yes.
And what did you do regarding that?
You asked me for my methodology.
Sure.
I'm now going to refresh my memory for my report with the court's permission.
Which you may do.
For the 2023 evaluation, I met with Ms. Geyser for an hour and a half in-person interview at the Winnebago Mental Health Institute. I reviewed the criminal complaint. I reviewed her records with the Winnebago Mental Health Institute with emphasis on those that had accrued in the interim between the 2022 and 2023 evaluation. I also reviewed a 16-page, at that time, wellness recovery action plan, which Ms. Geyser provided me with a copy of that she had developed. I reviewed her records with our office. I reviewed her records with the Wisconsin Forensic Unit. I also, on July 25th of 2023, had a brief collateral telephone contact with her treating psychiatrist, former treating psychiatrist at that time.
Did you, as part of that report, make your own diagnosis of what her mental state was at that time?
Yes,
And what was your diagnosis on the August of 23 report?
again, refreshing my memory from my report.
Just going to fast forward a little.
Post-traumatic stress disorder, social anxiety disorder, and unspecified schizophrenia spectrum and other psychotic disorder.
Do you,
All right, so that's kind of the main thing. The way that they're kind of asking questions, I'm going to skip ahead because I think her opinion is going to be that she isn't quite ready for release, but I'm going to fast forward a little bit.
She provided me about her history, for example.
Oh, and just a warning, the judge is going to cough a lot. I'm so sorry. The judge, at one point, he's in today's testimony, he actually pauses it so that he can cough. But the judge, I hope he's feeling okay.
In the interim between the two evaluations was mirrored in the record. But about that potential for anxiety symptoms or historic psychotic symptoms, that's the one area she's not been, reports she hasn't been a reliable reporter.
that institution-based risk assessment also included some statements that you found concerning, and I'm talking about October 24th of 2023. Do you remember that?
Yes.
And what was concerning about some statements she made during that assessment?
What was concerning was the content of them and the topic that they referenced.
And please explain that.
Perhaps it's best if I quote the record.
Please.
So the comment she made during an individual therapy session, kind of an emotion-charged individual therapy session in which Ms. Geyser has invested herself. So she's done a lot of work in individual therapy. But the comments that were memorialized in the clinical notes from the session on October 24th included, quote, "How do you think I was able to repeatedly stab my best friend and bitch face," referring to the co-defendant, "thought she was all the brains. I was pulling her along too. I didn't care. I couldn't care. I've never known how to care." End of quote.
That's something that stood out to you.
Yeah, that would be kind of a concerning statement. And I think they're going to say that she lacks empathy. So they are going to say that she does have a lack of empathy. And I think for the treatment facility, there is nothing that the treatment facility can do. And like, I think they're going to think they've done all they can do to advance her treatment. I think that's what some people that the defense is going to put forward. They're going to say that she's kind of maxed that out. But that statement would definitely be concerning to me. That she was kind of the mastermind of everything, because I think initially everyone kind of thought that the other friend that was involved in the incident, that she was the one that kind of had the idea, that she mentioned Slenderman. And for anyone that doesn't know, so Slenderman was this like rumor. It's not a real thing. It's like this faceless figure, and that he would either like it would harm children if you didn't unalive someone for it. And so that's what they were trying to do. But it sounds like this particular defense, like that she was already kind of psychotic and already hearing voices. And this just helped give a name to something that she was already experiencing. That's what some later testimony is going to talk about.
To you in your review of the records, true?
It stood out. I wasn't sure how to put context to it. So I knew, for example, that had been said. I acknowledged in my report that could have been merely emotion charged comments made in the face or in the context of therapy, which sometimes happens. For anyone who's been in therapy would know. On the other hand, this is quite recent to petitioning for conditional release and suggests, at least in that moment, a callous perception of herself. She later talked with her therapist about that and put that in terms of a question. So she reframed it and said, "How could I have cared if I did this to my best friend?" But the recency of it relative to her petition for conditional release, the reference to her co-defendant, and to herself, that was a potential red flag, at least for me.
Enough to give you pause as to whether or not she's appropriate to be released at this point?
Enough when taken in the context of the totality of information in this case, not just in isolation.
Because you indicate in your report that at this time, her release is a challenging call, right?
Appraising her readiness for conditional release is a challenging call, yes.
Why is it a challenging call?
Because of the multiple and several complex case characteristics, and the fact that Ms. Geyser is now approaching 22 years of age, and she spent virtually all of her adolescence and much of her young adulthood in an institution.
And so those types of institutions, they're not meant for people to stay long term. Now, she was there because of doing a crime and needing treatment, and them really needing to make sure that she was at the appropriate level. But her peers are all other people with propensity to harm self or others. Like, that's the only reason why people end up in these out of home placements, is because they are a significant risk to themselves or others. So she's only around other individuals that are at a similar or lower level than where she is. That's just kind of my interpretation of what she said.
In some cases, in most cases, I would say when I'm conducting a conditional release evaluation, I have a baseline for the individual of how they've functioned in the community as an adult. We don't have that in this case. All we know is how Ms. Geyser functioned prior to the age of 12 in the context of what appears to have been certainly dysfunctional, but also an abusive childhood.
And although all of this, as you indicate at this point, presents a challenging call, your call, at least to a reasonable degree of professional certainty, is that she still presents a significant risk of harm to herself or others and is not at this time appropriate for release.
Yes.
All right. So then the defense is going to come back and ask ask her some questions. They are, of course, going to disagree with her statement. I am going to skip ahead to the next expert. I have no clue who this is. We are all watching this together. So let's skip ahead.
Spell your last name.
My name is Dr. Brooke Lundbohm. First name is spelled B-R-O-O-K-E. Last name is L-U-N-D-B-O-H-M.
M or N?
M as in
M.
Mary.
All right, very good, thank you. All right, Attorney Nicolai.
Thank you, Judge. Dr. Lundbaum, I'm going to hand you what's been marked as State's Exhibits 3 and 4.
I believe those are her reports. I'm going to fast forward a little bit.
The waiver or reverse waiver regarding whether or not a person should stay in juvenile court versus adult court. I have done guardianship evaluations, some civil commitment.
Skipping ahead.
In my interview with her for a conditional release petition in June or July of 2022, there was some beginnings of that shift, although it's not quite like her report in the last 2 times that I've met with her. By fall, so for sure November or so, there's clear indication in the record of the shift in how she's been self-reporting her mental health issues.
Could you summarize that shift on a timeline for the court?
So since the index offense, so there has been ample information, observations by various mental health professionals, people who have been involved in her care, across settings, across time, that consistently portray her as an individual with flagrant psychotic spectrum symptoms. Things like delusional ideas, auditory and visual hallucinations, tactile hallucinations or related to touch. There have been indications of thought disorganization, bizarre behavior, bizarre comments. And this would be consistent, again, across reporters, across time, across settings, that these different observations have taken place. The conceptualization with that has been a schizophrenia spectrum disorder. Beginning in 2012, she began to say that she feigned psychotic spectrum symptoms. There were also, prior to that time, her report.
She said 2012. She might mean 2022. I don't know if she means 2012. I'm not sure. She might mean, because I do think the professionals believe that she was experiencing psychosis.
Of significant mistreatment during her childhood by her
You
father.
said 2012.
2014.
All right.
Okay, I'm glad she clarified that because I was confused. So 2014.
I believe is the index fence. Sorry. But by that point, the treatment that she was experiencing at Winnebago shifted towards a diagnosis of post-traumatic stress disorder, with her report of feigning psychotic spectrum symptoms. Through those records, there was eventually the discontinuation of a schizophrenia form disorder.
So I just want to make sure that the court is clear on the timeline that we're talking about. So when I think that you misspoke and you said that the feigning began in 2012.
Oh,
What year did this shift begin?
so she began reporting that she had been feigning the symptoms in about 2022.
Okay.
There we go.
And saying that the various observations going even before the index offense were the product of her essentially faking. The data, though, does not support that.
So let's talk about that a little bit more. Can you?
And so I just want, next of Kim, thanks so much for being here in the chat. I really like, there's a individual with schizophrenia on YouTube. She's a content creator and I follow a lot of her content. Sarah, you are not super late. I just started, maybe like we're just kind of getting into this. So we're good. But with schizophrenia and with psychosis is a break with reality. And one of the biggest things that I haven't said yet is there can be a lot of misconceptions about the diagnosis of schizophrenia. And it came up with another case I was listening to. I don't remember which one it was, but people were describing it almost as multiple personalities. And that's dissociative identity disorder, because schizo, the way that because schizo means split. And so sometimes people will describe it as split personalities, and that is not at all what the experience of schizophrenia is. And I have diagnosed that diagnosis in individuals. I've also worked with people that have major depression with psychosis or bipolar disorder with psychosis. So just because someone is hearing voices, seeing things, or having delusions, it doesn't necessarily mean that they have schizophrenia. There are a lot of different diagnoses that can influence that. And when we bring up Dr. Lewis, I don't think Letitia Stout, I don't think that she was experiencing psychosis at all. And this was one of those true cases where an individual, because immediately after the offense, Morgan, she did not think that she did anything wrong. Like she did not, but she did not seem to be connected to reality. And that's what schizophrenia can, that's what some of these diagnoses can do. Typically, an individual is a higher risk to themselves than to somebody else. And so anytime somebody has command auditory hallucinations, and those are hallucinations that are telling them to do something, that is where I as a therapist, I get very concerned. Some people, because there's a range with psychosis. So with any symptom, there is a range of severity. And I've worked with people that just had their psychotic symptoms was just like a radio playing in the background. It was just, they never knew if they were out in public and they were hearing something, they never knew if they were actually hearing it or if it was something that was in their head, if it was an internal thing. There are medications that can be really that can help. The medications can have a lot of side effects, and so that's where people that's where things like that can come up. And there is, so for bipolar disorder and schizophrenia, with the research that we've done so far, those are the two diagnoses that do tend to have a pretty high genetic component. And we do believe that Morgan's father had schizophrenia, which any child, so if only the dad had it, there might be about a 50-50 chance that any child might live with that diagnosis. I like talking about living with diagnoses because a lot of people are able to live well with support. And I'm still on the fence with where I am. The defense experts from today, they really did, like, I was really agreeing with what they were saying. But let's listen to this expert a little more. So let's keep going. Let me know if y'all have questions in the chat.
Talk with the court a little bit about how Ms. Geyser's history is more consistent with her actually having had that psychotic mental illness.
Yes, so there is indication in the data, even prior to the index offense, where she was described as eccentric, engaging in odd behaviors. There were at least one time at school where staff had documented concerns that she was observed speaking to herself as if she was responding to stimuli that was not there. That was around the same time that there was an incident which she had brought it's variously described as a mallet or a hammer to the school, which resulted in her suspension. There was ample information through the discovery materials related to a fixation on Slenderman in part, but also other different kinds of characters or other morbid themes. It was revealed that she had been engaging in odd behaviors, including, by her own admission, she was engaging in what she called a medieval torture game. There was some indication that she had disfigured dolls that she.
And just because someone is engaging in odd or behavior that's against the norm does not necessarily mean that it is psychosis or anything, but there are going to be other things that kind of make us, like, that would make a therapist or psychologist, psychiatrist. There are other concerning things that I think definitely raise red flags in this case. And a person with this diagnosis, so I don't know that that diagnosis alone would mean that she shouldn't have conditional release, because they're talking about releasing her to a group home. So they're not talking about her going to live with a family member or her like living on her own in an apartment. They're talking about stepping down to a therapeutic group home where her medication, her location, all of those things would continue to be monitored. But it would be a lower level of care. And like I'm still on the fence. I do not envy this judge, because this judge is looking to protect not only the community, but also this individual as well. And it sounds like she has, in the last few years, she's been a risk to herself. And so
She had lots of drawings related to kind of these morbid themes, these different characters. After the offense, immediately during her interview with the officers, she displayed.
I just want to clarify her diagnosis. So Sarah, they had diagnosed her with schizophrenia in the past. I think the current psychiatrist, because of the addition of PTSD, so there can be psychosis that goes along with post-traumatic stress disorder as well. And so I think the psychiatrist, they were thinking with resolving her trauma that might resolve some of her psychotic symptoms. And I believe she's come off of her antipsychotic, and she's only on anxiety medication to this time. To my knowledge, I have not heard the survivor speak at this hearing. Um, if I could guess, I would think the survivor would not want her to be in the just like that's just, I'm guessing the survivor, but this isn't like a parole hearing, like because she was found guilt not guilt, or she has a mental health verdict. Because of that, I don't know if they're going to take the survivor's request into consideration. I'm just being honest about it, because it's not like a parole or probation thing. And if they did step her down and she needed to step back up, she could always step back up to a higher level of care if she needed it. So if she stepped down to a group home and then she had like she wasn't being safe, she wasn't complying with treatment, they would step her back up to residential, because she's been sentenced to 40 years. The other individual involved was sentenced to 45 years. My camera, because I'm at the office today, so my camera is going to keep pausing, but I think y'all can hear me, so we're good. Hopefully the stream doesn't pause. Oh no, we'll see. The stream might pause. I'm getting the circle, that horrid circle. Let's see. There we go. Good gosh. I tried to lower the quality. I'm not connected like I am at my house, and so hopefully this helps. So we're going to hop back into hearing and try to find our place with where we were, with the testimony about her history of possibly of meeting criteria. And they are proceeding with it today, and so I'm keeping an eye on that in the background as well. So let me go on ahead and share my screen. And I know I would never ghost you all. I would freeze. I would definitely freeze. That happens all the time, unfortunately. But hopefully hopefully with me editing the behind the scenes, hopefully that helped. All right. So let's we're not exactly where we were, but let's see.
Doesn't line up. And so there's a significant concern about the reliability of what she says in her presentation and being able to understand where things actually are within any given moment of time.
Would you say that this change in her self-perceived mental illness has in fact made this case more complicated than if you would have been dealing with a schizophrenic individual undergoing treatment?
In my personal opinion, it does. For me, doing the conditional release evaluation currently, there are a number of different, what I would say, branches that her case now goes off onto that you have to consider of, well, if this is true, then I need to consider these risk factors related to her risk for violence. On the other hand, if this avenue or branch is true, then there are other considerations to make. So being at this stage, with a conditional release evaluation, this level of uncertainty and complexity, in my experience, is a bit atypical. And given the complexities of risk assessment in and of itself, creates a more challenging conceptualization and report.
In cases where you've supported conditional release, was there markedly less complexities in your analysis than this case?
Every case is different. I mean, certainly I've done a number of cases where there are quite a number of complexities, but the market shift in Ms. Geyser's particular case is striking and does create these extra complexities that lead me to the opinion that she's not currently safe to be discharged to a less restrictive environment under conditional release.
So I think the hard part about this one is she's going back and saying that she was never psychotic, that she was never experiencing psychosis. And the hard part about that is it sounds like there are people that observed her responding to internal stimuli, or the psychologists aren't sure if that's accurate. And so, yeah, let's go on ahead and let's see how much longer. I'm going to skip ahead to today because she talks a little bit more today. And so let me switch over to that stream, share this tab. She continued with part 2 of her testimony today. And it's a little bit more of the same, but there were a few other experts, and the judge calls someone specific to give feedback as well. And so and for anyone that's ever experienced anything like this, if parts of it get to be too triggering or anything, please feel free to step back. I have the reason why I don't do forensic is because I believe what clients are saying and showing me. And there were times when I saw a client begin to decompensate, and I was pretty sure that they were experiencing delusions and psychosis. And I gently handle that. And I worked with their family members to make sure that safety, because safety is always my biggest priority. And so that's why I don't do forensic, because my goal is I want to believe that people are telling me the truth, but I'm not naive like Dr. Lewis. I'm not naive to think that people won't try to lie, or that people don't try to say kind of different things. And I think what she's thinking is that this particular expert believes that Morgan thinks that she'll be a better candidate for release if she didn't have a schizophrenia diagnosis. And so I think that is her opinion on this.
2022, there's been inconsistency, both with respect to her, in the moments of those interviews and her trying to, I would say, struggle with her history of mental health and putting it into an explanatory framework. But also there's inconsistency when you compare it to her past report, the past observations. And so the reliability of her self-report at this point is a concern to me.
And that's kind of my question. I'm asking specifically about contemporaneous reporting of immediate symptoms that are ongoing in her.
And I do believe that this is the defense that is cross-examining her right now.
Medical records and what she's reporting. Has she been historically accurate in looking back, her self-reporting matching what is being documented by her care providers?
No, I think that the recency, the issues of the most recent years place all of that in question. So there's a real concern about whether or not she is, in fact, being forthcoming about what she's actually experiencing. As an example, within the moments of even our interview, describing essentially no history of psychosis whatsoever, really saying that her minimizing, if you will, what is well-documented, repeated incidents of heightened reactivity, intrusive memories, ongoing incidents of dissociation. And so that self-report, at least to me, was not consistent with the data that's there.
let me ask this in a different way. What I'm trying to get at is it true that Ms. Geyser right now and in the previous months has reported anxiety symptoms, has reported PTSD symptoms as they have occurred to her treatment team and providers?
What I would say is she reports it and demonstrates it. There are times where she is demonstrating those kinds of issues, and it's been hard for her to express what is actually happening in those moments, but she's been very actively engaged in treatment and in the wake of those incidents, processing her ongoing symptoms.
Would it be fair to say that Ms. Geyser, in the moment of experiencing those symptoms, accurately describes them, articulates them to her treatment team, and her self-reporting is consistent with observed phenomena, let's say? In that moment of her actually experiencing these symptoms, is she truthful and accurate and forthcoming about those in the moment?
It appears so.
And so the difference, I guess, in the accuracy of historical reporting for her comes in her after the fact rationalization of what has or hasn't happened. Is that fair?
I think that's fair, yes.
And this, we can kind of even see in your interview of her, where she talks about feeling as if she does not have, empathy, while also expressing remorse and characterizing the things that she's disclaiming present tense. Is that true?
Right. I think that there is some inconsistency in that between what she displays versus what she is reporting. And I think she's continuing to wrestle with some of these complicated issues and is doing so on her own, but also with her treatment team.
Do you have any concern that she is not reporting symptoms as they occur to her treatment team, present tense?
I have no information to suggest that that would be true.
You have no information to suggest that she is not reporting or that she is?
That I would have no information in the records to suggest that she's experiencing things that she has not reported to the treatment team. That said, it's also difficult because some of these things, when we're talking about a psychotic spectrum disorder, they're not tangible. The rest of us can't see or hear what she may be seeing or hearing. The rest of us don't necessarily perceive the environment the same way that she does. And so one of the things that's very important to me when considering her readiness for release is that we want her to be reliable. We want to be able to trust what she's saying so that we can put appropriate supports around her, ensure that she's doing well. The goal of conditional release is to have her in the community, not only safety for the community, but safety for her. And that reliability and being able to trust that self-report and her being able to recognize that in herself is monumentally important.
All right. And so she makes that point. I'm going to fast forward to the next expert. She's going to talk for a while longer. I'm not sure. I think they're just sitting there with the judge. Yep. Okay. Let's see. This is the next expert. This is a psychiatrist. And I do believe that this is an expert that the defense is calling.
The whole truth and nothing but the truth, so help you God.
All right, very good. Thank you. And then Attorney Cotton.
Good morning, Dr. Robbins. I'm going to just start by asking you if you have.
So once again, trigger warning for essay and then also unaliving attempts. So those are my trigger warnings for his testimony.
Tell just one housekeeping matter. State your full name and spell your last name for the record.
I'm going to fast forward past that part.
I did. We've marked that as Exhibit A.
He has a report.
Madam Clerk, I believe it's in the Exhibit Q. You've had a chance to review that. Is that an accurate resume that you provided to our office?
It is.
Judge, without objection from the state, I'm just going to move into admission, request admission of Exhibit A.
Any objections?
No.
All right, received.
Dr. Robbins.
Is there an exhibit list?
Yes. You have an exhibit list that you're running?
For anyone that's new, just a warning, the judge is going to cough a lot. Okay. And so this is the psychiatrist giving his testimony.
Oh, it's the attorney should prepare an exhibit list.
I'm going to fast forward.
To medical school at University of Michigan.
Going to fast
graduated
forward
in
through his
19,
history.
Treated to competency or being treated for not, after they were found not guilty by reason of mental disease or defect.
In other words, people like Miss Geyser,
Exactly.
somebody who was treated for competency, found NGI, placed at an institution.
Correct.
During the 90s or decade or so that you were the medical director, did anybody from Mendota ever petition for conditional release? Did that ever happen?
Oh, many times.
Okay. Were you involved in, well, you say many times, were you involved in any of those cases or did you oversee them?
Yes, I essentially oversaw all of them and participated in looking at some of the letters that the Institute wrote.
And as the medical director, you're essentially in charge of what comes out of that institution. In other words, if a doctor recommends release, you're going to see that report and you're going to have your own opinion on whether that's appropriate or not.
Well, to some extent, the doctors who recommend release or who suggest that release is not appropriate are independent of the institutes, as in my case. So I have some role to play, and because the institute writes a letter bringing the court up to date on how the particular person is doing, but the institute doesn't make a recommendation.
And in that letter that you talked about is more or less is it a risk assessment or an overview of their treatment progress or both?
Essentially both. It mostly focuses on behavior, how someone has done, how they participated in care, the clinical progress as well as the behavioral progress.
How do you know as a clinician, how do you know when somebody's ready to be released to the community?
That's a good question.
Well, it's a somewhat subjective decision based on a belief of whether they are dangerous, for starters, whether there's something more important that they need to still receive at the institution, how they've done, how they're likely to do outside the institution, what kind of behaviors they've displayed when they've been stressed, etc.
And once release is recommended, just make sure the camera didn't freeze. Can you hear me, Dr. Robbins?
Oh,
Yeah.
the camera froze.
Just had a brief
We
glitch
know
there
all
with the
about that.
camera, I think. Once an individual is approved by a court to be released, what does the institution do? What would Mendota do, for example, once a judge has signaled his or her approval?
Well, they would look to meet the conditions that the judge lays out, but they would look to make sure that the person who's being released is being released to a safe environment where they can be monitored.
Okay. What's your opinion specifically about Morgan and her petition for conditional release?
My opinion is that this is an appropriate time for her to be conditionally released.
In your report, you said that it's an ideal time for her to be released. Why is it an ideal time right now?
Because Morgan has improved quite dramatically and needs things that the institution can no longer offer. I think she's benefited a great deal by being at Winnebago in many different ways, but I think she's reached the end of what Winnebago is able to help her with. There's no suggestion that she is dangerous at this time. And the kinds of things that Morgan needs, in my view, help with socialization, help with education, help with becoming independent, are things that Winnebago can no longer provide in an effective way.
Okay, so I think that's significant. The fact that I think he might be like the medical director, or that somebody in a high position at this facility that he does not feel that they have what's needed to meet what she needs going forward, that she's kind of maxed out their treatment, what their treatment can provide. And sometimes in these types of placements, what constitutes stability is sometimes like 2 to 3 months of just no major things. She's at their highest level because I guess they have different levels with complying with. Sometimes they have, it's like a reward system, or but they have a level system, and she's been at their highest level. That is really, really interesting to me. And he's gonna go a little bit more into why he thinks that. He does think that she should continue with education, and the fact that she doesn't have peers that are kind of on the same level, that's another thing that's kind of influencing his decision. Okay. And then, so I want to hear from the expert that the judge asked to come back. All right. So let's hear from this person. Morgan is right there. Somebody mentioned her hair, and if you see them show her, because her hair has appeared fuller in the past, and sometimes some of the antipsychotics can cause hair loss, but also sometimes people can pluck hairs for anxiety. And I don't know what her hair loss is about, but I was in the chat, I think probably for Law and Crime, and I saw people talking about that.
This Geyser.
Yeah. I'm going to fast forward. So they are going to bring the other expert back.
This is a civil proceeding.
I do too.
All right. State agrees?
Yes.
All right. All right. Very good. Thank you.
So the judge was clarifying this is a civil proceeding and not a criminal proceeding. So this is a civil proceeding. This judge has been coughing all into the mic. I'm so sorry. And we skipped over because there was a point where it got really bad. I think through that last expert's testimony, or maybe it was but like it got really bad. All right, let's keep going.
With that, then the defense rests.
Yes, Your Honor.
Does the state have rebuttal testimony?
No.
I asked Dr. Pope to be available from Winnebago. She's been on Zoom on both days. And I'd like to ask caller to have her answer some questions. Should be brief. Any objections from the state?
No, not at all.
Any objections
No.
from the defense?
No.
Okay. Dr. Pope, are you there?
Yes, I am, Your Honor.
Okay, I'm Judge Boren. I think we've met before. So good afternoon.
Good afternoon.
You've been listening to you've been listening to what's gone on in this case by Zoom yesterday and today. True.
That is true.
I'd like to call you as a witness and just ask you some questions about what's available at Winnebago for treatment. So now, if you're prepared to do that.
Yes, I am, Your Honor.
Okay, then I'm going to have our clerk swear you in. Could you stand and raise your right hand?
Okay, so if you have 2 headphones in, you need both headphones because like the judge's audio is coming through one, or I don't know if it's just mine. Yeah, so if you have two headphones, or if you only have one headphone in, you might need the other headphone to hear her loud and clear. She's coming in through my left ear. It's on your TV? Okay, sorry. I don't have any ability to increase the audio, Jess. I'm so sorry. Okay, he's going to swear her in.
It's Dr. Kayla, Kayla, Pope, Pope.
And what position, and you hold a position at Winnebago Mental Health Institute?
That is correct. I'm the medical director.
And because of that position, are you familiar with Morgan Geyser?
Yes, I am, Your Honor.
Medical director, you hold a medical degree?
I do, Your Honor.
Are you also licensed as a psychiatrist?
I'm, yes, licensed and board certified in both child psychiatry and general psychiatry.
All right.
So I got it wrong earlier. The other guy was not a medical director. Y'all know me and my mistakes, my bad. But yeah, so she is the medical director for the facility.
Have you been familiar with, how long have you known then Morgan Geyser?
Since July of 2019.
All right, so you have long-term history with her.
That's correct.
There's been a lot of discussion about in the petition and in the response to the request for release on a conditional release petition as to what's available at Winnebago if she's not released, and what is the proper course of action for her in the future. Are you prepared to comment upon that?
I am, Your Honor. So it has already been identified by the experts. Morgan has already reached the highest level of privileges at Winnebago. She has actively participated in therapy, medication management, and all the treatment rooms that are available. At this point, she has optimized all that is available for Morgan. And as Dr. Robbins pointed out, we have very little ability to provide Morgan with experiences in the community. And I would agree with him that at this juncture, it's critical for her to have those experiences to help her continue with her development and socialization.
So as far as experiences in the community, so with a residential care place, you just stay there. Some do outings. So I used to work at a pediatric residential care facility, and I think maybe once a week, or sometimes it was once a month. It wasn't every week, but it was maybe like once a month or maybe every other week. We would do outings off campus or off site, where we might go to, but normally it wasn't for very long, because individuals were in that facility because they had trouble being safe out in the community. And those outings happened so rarely that normally I never had any issues with the kids while we were off campus. Most of the issues would happen on campus. But yeah, and so group homes normally do more outings. And the recommendation is going to be a step down to a group home. Not sure if that's what's going to be decided.
With if she remains at Winnebago, what impact does that have on the risk assessment as to her dangerousness?
I don't think it would have much impact. I think at this point she is safe to return to the community, and I don't know that there's much more that could be done to make her safer.
Dr. Robbins, in his report and in his testimony, recommended if she is released to a group home to facilitate further acclimation into the community. Has that been, you have experience with that type of remedy?
I do, Your Honor, and I do think that would be an appropriate placement for her.
All right, thank you. I have no other questions.
Okay.
Attorney Zapakowicz, questions?
Doctor, have you reviewed the reports of either Dr. Collins or Dr. Lundbaum regarding conditional release?
I have just glanced at them. I did not review them in detail.
You're aware that both of them find Morgan at this time not suitable for conditional release?
I did hear their testimony to that effect.
And they believe that Morgan still represents a significant risk of bodily harm to herself or others?
I did hear their testimony to that effect.
You don't agree with that?
I would say I probably agree more with Dr. Robbins' assessment of the situation. Morgan has not had any dangerousness for several years now. And I do think at this point it is critical for her to make the transition to the community to help with her ongoing development.
You don't believe 6 months from now she would be less ready to go into the community, do you?
No. But I do think that critical period for development is closing, as Dr. Robbins identified.
Because there might be so like right now, all of her food is cooked for her. It's like with residential, she's probably on eyesight supervision. I remember when I worked residential, there were people that monitored them during the night, and actually did night monitoring at because it was easier and you got paid double and they all slept because they were on significant medication. The facility I was at and they were heavily medicated. That's why I left that facility after 6 months. It wasn't the right fit for me personally. I was a staff, so I wasn't a therapist. I was still working on my master's at the time. I was a staff person, and I felt like I wasn't helping, and so it was really hard. And this was a child facility. It was really hard to see how people could get better. So if they didn't need to be there, I definitely wouldn't recommend it. I also get the concern about the change in her diagnosis and her coming off of her antipsychotics, because I do think the psychologist, if there was insight, or but that can be an issue sometimes. I don't know. And then also with the age she was, because she did not disclose the harm that she alleges her dad did until after his death. And so she was carrying a pretty significant secret with her for all that time. And I've seen trauma present in different ways. And so I don't know. I don't know. I get both sides of it, but this is really, really difficult. I did star a question from earlier. Kelly, I hope you're still here. How easy is it for anyone, young adult, to fake it? Or can like a doctor be fooled? And so mental health, a part of it is self-report. Now, if they saw her responding to internal stimuli, but there are people that can experience psychosis and you not know it. And so that can happen. And that type of lockdown facility, you would think it would happen less often. Like you would think that would be hard to do, but I'm not saying that it's impossible. Yes. And so that's where I don't know, because yes, I don't know. And she did not disclose anything until after her father passed. I think she did say something to her mom possibly before he died. I think I heard a little bit of that in here.
And you don't really have any experience with Morgan going back to 2014 when this offense was committed, do you?
No, I was not involved in her case at that time.
And are you aware of the underlying facts of that incident in any detail?
I am aware of what transpired to some extent, but not in detail, no. I was not involved with the case.
Nothing else, Judge.
Right, thank you. Any questions, Attorney Cotton?
Thank you, Doctor. The team at Winnebago will work with Morgan to figure out the right way for her to transition, right?
That's correct. They'll work with her community team.
She already has a team that's been put together waiting for the judge to approve things, right?
That's correct.
And so if Judge Boren gives the green light today or tomorrow, is that team ready to meet and put pen to paper and figure out the plan?
I think the process is there's a 60-day period for them to put together a plan.
Okay, and then they file it with the court to see if the judge approves.
Next of Kim made a really great point, and you've had really, really great points throughout. And so the fact that that she's making some of these statements, and so I don't know why her current team isn't, especially with the family history of schizophrenia, I don't know why they aren't ruling that out harder, especially with all of the documentation and everything that happened. And I have seen sometimes things get misdiagnosed or things not be quite right, but it does sound like at minimum there was some type of psychosis that was being experienced. And right now, I think she desperately wants to leave. And I have seen people want to say or do anything to get released. And people in those types of facilities, they know, okay, this is how you get out. And so I don't know if there's a secondary gain. It's, to me, it sounds like she could potentially misrepresent things. So the state is going to talk about why they feel that she needs to continue to be under supervision. I think we're going to start probably somewhere in the middle of that. So this is happening right now. Let's see. All right, so let's go. And I do just want to trigger warning. They are, I think, going to describe what the victim in this case experienced. So trigger warning for that.
And conditional release that have devoted their careers to the area of forensic psychology. Dr. Collins, I believe, testified she's done thousands of competency evaluations, thousands of mental responsibility evaluations, and at least hundreds of reports regarding suitability for conditional release. I think they're.
And I just want to clarify something. And so let me see. I want to clarify this statement because so she has achieved progress in her treatment, and the facility feels like she's capped out the goals that are available at their facility. And so I wonder if there's another inpatient facility that might be a better fit. I don't know if that's an option, like a transfer to a different facility, not quite a step down, but like maybe there is another facility that maybe does have more availability. I don't know. But typically for residential, you're not getting as much, what's the word? You're not getting outings. Your peers are probably severely mentally ill and actively needing treatment. And I think that's kind of what they're saying with this. And so, yeah.
Experience in this area is extensive, and their opinions present clear and convincing evidence. Each of them also, Judge, has a great deal of experience with Morgan Geyser. Dr. Collins, presumably because of her expertise, was hired by the defense in this case. Right after the offense happened, she was hired and I believe met with Morgan for the first time sometime around June 4th or 5th, 5 days after the offense actually happened. She knows Morgan better than any of the doctors that have testified. She's had a longer period of time with her. She knew her back then, immediately after the offense occurred, and has had the most contact with her throughout the course of the almost 10 years. Both of these doctors, Judge, drafted lengthy reports that were thorough and detailed. I guess I can't really say that quantity equals quality, but I think when you look at the reports of Lundbaum and Collins, certainly the quantity shows the amount of effort and detail that they've put into writing their reports and that they put into arriving at their conclusions. Certainly, in my opinion, much more so than Dr. Robbins. His report is 6 pages long. It doesn't have the same detail. It doesn't have the same thoroughness. It doesn't have the same recitation.
But Dr. Robbins is a psychiatrist. I hate to be, but like psychologists are sometimes trained to like say things, I don't know. Like I think it's a difference in training too. But
Of what's gone on at Winnebago with Morgan in terms of treatment and therapy, their reports, Judge, I submit, are better. They're more well done, And I think the fact that they are that gives them better quality than the report, and ultimately a better conclusion than is arrived at by Dr. Robbins. And I thought the testimony of Dr. Lundbaum regarding her description of the different paths that this case can take was very informative. I think it showed that she didn't start out, Judge, with, I'm going to find a way to keep Morgan Geyser in. She looked at everything and assessed everything, and that took her to the conclusion that she arrived at. Both recognize the improvement that Morgan has made and admit that release will happen, but she's just not there yet. Dr. Collins opined that 6 months to a year was needed to satisfy her that the risk was no longer significant.
And I think her being off of the antipsychotics for another, because I think she might have come off of them maybe in 2023, potentially. Correct me in the chat if anybody has followed this a little closer. I think in 2022 or 2023 was when she came off, because right now she's only on the anxiety medication. That's my understanding.
Both of those doctors included, Judge, the legal standard in their reports. That wasn't anywhere in the report of Dr. Robbins, and I think his view on it, at least in my opinion, was somewhat incorrect in terms of the law. He felt that he could balance what was in Morgan's best interest against any potential risk. And if the benefit was greater to Morgan than the risk was to the community, well, that meant she should be released. That's not the legal standard, Judge. There's nothing in 971.17 sub 4 sub D that talks about the court looking to the best interest of the person who is under institutional care. It says simply that the court shall grant it unless there's clear and convincing evidence of a significant risk. I don't even necessarily think that, I know the opinion of Dr. Pope, which I guess maybe I should have looked into it more, Judge, but I felt kind of blindsided by it. I had not spoken to Dr. Pope. I didn't know that she was going to be testifying. I didn't, we don't have any report from her. I don't have a CV. I don't necessarily know much more than she's been with Morgan for 5 years. But in any event, she seemed to opine that Morgan needed more experiences within the community, that based on her age, it was time that she start receiving those, that would be in her best interest. But again, that doesn't speak to whether or not there's a significant risk. I know she did say that she didn't feel there was a risk, and she was more aligned with Dr. Robbins. But again, without having a full report from her and knowing the entire basis for her opinion, I don't think the court should give that opinion as much weight as Dr. Collins and Dr. Lundbaum deserve. Dr. Robbins, he had it wrong in his report. He said that this was Morgan's second time petitioning for conditional release. Well, we all know it's in fact the third time. I don't know why he waited until today to review the report of Dr. Collins. That was filed on March 5th before the report of Dr. Lundbaum, but he, in his report, it only mentioned reviewing Dr. Collins's August report. In any event, Judge, what I think I have the biggest issue with that Dr. Robbins included in his report was on page 4, where he He indicates that the case is tragic, and he indicates that this is a particularly tragic story with many victims. No, there are not many victims here, Judge. There's one victim. There's one victim who almost died, and that was the victim in this case. There's one victim in 2014 CF 596. He states, including, of course, PL, but also including Morgan. I don't accept that, Judge. Morgan is not a victim in this case. If Morgan was a victim of her father, yes, that is also tragic. But the only information we have about that comes from Morgan. The information we know about our victim is that she was stabbed 19 times and left in the woods to die by Morgan and Anissa Wire. We know that she was found by a citizen witness because she cried for help. Help me, I've been stabbed. We know emergency personnel came to the scene, found her covered in blood. We know she was taken for medical treatment. Doctors opined that she was within 1 millimeter of losing her life. She had significant injuries to her liver, pancreas, and stomach, all of which had been stabbed. Her heart was struck by the knife. One victim in this case, Judge, and that was her. And she'll be a victim in this case for the rest of her life. She will have significant scars that she carries with her for the rest of her life as a result of what Morgan Geyser did. I would be remiss, Judge. I think Marcy's law requires me to let the court know that the victim's family is vehemently opposed to the release of Morgan Geyser. I know they indicated they did not wish to make a statement, but certainly wanted me to convey that to the court. So is there significant risk here? Well, Judge, Morgan Geyser tried to kill the victim in this case, and then 7 years later, she tried to kill herself. That was less than 3 years ago. I think that alone shows there's risk here. And the fact that it's a significant risk is supported by the doctors in this case. One of the other things that Dr. Lundbaum testified to today was, well, I guess I should go back. I touched briefly, Judge, it's not clear if Morgan was a victim of her father. The only evidence we have comes from her. We have another issue that was brought up by her about, well, was she faking all these years? The doctors say no, but I guess the question then becomes is, why is she saying that now? We don't know. That's not clear. We don't have a clear answer on that. We don't have a clear answer, Judge, on why she committed this offense. For years, the thought was, well, she's suffering from schizophrenia. She believed Slenderman was real. She believed Slenderman was going to harm her and her family. And she felt that she had to do this to appease him. Now we're getting a different version. We're hearing, well, she believed in Slenderman, but she wanted a way out of her family situation. So the motivation here is no longer even clear. Dr. Lundbaum testified today on some of those points, and I think the question became, and I know is a question for both of the doctors, is can Morgan be trusted to report her symptoms? Dr. Lundbaum testified that this raises serious concerns. Not her only concern, but certainly serious concerns. Her reliability of her self-reporting is hard to know. That
Okay, so I just want to show you all a little clip of her police interrogation. And this is from a, let me see, it's a ABC News. I will put the link over in the chat. So it starts with the victim sharing her story. And in talking about all of this, I just wanted to highlight this part. And this is the thing that really concerns me. And this is why I'm so on the fence with this one. So let's watch this part real quick.
Morgan.
So the picture that just flashed was Anissa. That was the other individual. This is Morgan.
It seemed like she was very calm, very relaxed. I mean, she's at a police department and she's covered in blood. And this is like a normal day for her.
You can hear Morgan ask what's happened to Peyton using her nickname, Bella.
Is she dead? I don't know. She was taken to the hospital. What? I was just wondering.
It didn't seem like it really concerned her too much if she was dead or alive.
The detectives read the girls their rights.
You have the right to remain silent.
Here in the state of Wisconsin, a child can be interrogated without the presence of their
So this is Anissa's mother. Anissa was the other individual.
parent or guardian being in the room. At that time, I did not know that.
We find that people are more truthful when they don't have their parents present.
This is going to get me arrested, isn't it?
The interrogations last for hours.
You think these all gets a little bit more comfortable here?
I have a daughter that's almost the same age as her. Like, she could be my daughter, but then she started saying things that were really very eerie, hearing them coming out of a 12-year-old's mouth.
So did you guys talk about doing this beforehand?
Anisha told me we had to.
Why?
Because she said that he'd kill our families.
Who's he?
A man. I didn't know him, but Anisha knew him.
And this is where the story takes another turn to a fictional character on the internet.
There's this website called the Creepypasta Wiki. It's full of like horror stories that are meant to purposely scare you. And there's one of them called Slenderman.
Who's Slenderman?
He's this tall, faceless man who preys on children. At his own will, he can like exploit these tendrils from his back and like strangle his victims. From what the Creepypasta Wiki said, he targets children most.
Anissa explained to me that to prove yourself worthy to Slender, you would have to kill somebody.
Morgan said we have to kill Bella.
When we come back.
Did you feel bad? They just stabbed one of your best friends.
I thought about it, but then I decided that remorse will get me nowhere. It's easier to live without regrets.
That's the statement that like, I don't know. And she was 12. She was 12, but still, and she continues to show a potential lack of empathy. And so that's where, and so Sarah asked a great point of why was she allowed to come off of her antipsychotics? And at 21, because she's in her 20s now, I think if her treatment team thought she had to be on antipsychotics, I think they would because she's institutionalized. She's on a mental health hold, And so they probably could compel her to take medication, even if she didn't want to take it. It sounds like her treatment team agreed to see. And this was not described, to my knowledge, within this hearing, but it sounds like they tried her without it, saying like, "Hey, tell us if if things kind of come back." And this is her third attempt to get early release, and I'm not sure if some of this is her trying to have the best case for being released, and that is concerning to me. So let's keep going.
That makes her a significant risk. Dr. Lundbaum questioned, is she motivated to reliably self-report? Is she willing to self-report? Or is she not going to because she wants to be released and to stay released? That makes her a significant risk. I would direct you, Judge, to page 33, at the top of that page on Dr. Collins's report, and page 30 of Dr. Lundbaum's report. Those are their conclusions and their arguments, Judge, as to why there is significant release here and why they cannot support release at this time. So the state is asking that you follow the recommendations of those two doctors and not allow Morgan to be released at this time.
All right.
I apologize for the judge's coughing. I apologize. I hope he feels okay.
Thank you. Then I'll turn to Attorney Cotton.
Thank you, Judge.
That has he taken it? I don't know. I think he is sick. I think he is very sick. Poor judge. Oh my God.
As the state notes, the statute states as follows. The court shall grant the petition, shall grant Ms. Geyser's petition, unless the state proves by clear and convincing evidence that Morgan would pose a significant risk of danger or great bodily harm to herself or others, or serious property damage. Clear and convincing evidence. That means that the evidence is highly and substantially more likely to be true than untrue. Colorado versus New Mexico, 1984 Supreme Court case. The court obviously knows that standard from its years on the bench.
Okay, so I'm gonna skip through this part because I'm not sure how much time I have left. So I'm gonna skip ahead a little bit. All right.
Restrictive environment. For those reasons, I'm asking you to grant the petition.
All right, thank you. I appreciate your comments. Attorney Patrice, any rebuttal argument?
I don't, Judge, no. Thank you.
No. All right, thank you. Thank you for the good arguments.
Fast forward.
Petition the rule, and I'll rule this afternoon with regard to the petition for supervised release. As was with the doctors that testified, the court's been involved with this case since the beginning. And as is Mr. Zapakowitz and as has Mr. Cotton. So the history, the anecdotal history of the case goes back for the length of the legal proceedings on all sides and in all facets. The just an initial comment. The court asked Dr. Pope to be available from the beginnings in the event it was necessary that she testify. The issue of what happens at Winnebago for Ms. Geyser at this stage of her tenure there has been in the case. Everybody talked about it, that there's no place else to go, there's nothing else out there. I thought it was necessary that somebody from Winnebago be here to tell us what it really is, so we know what the status is. That's why I asked her to be present, and she repeated, didn't repeat, but she said what other doctors had said, that basically there isn't any place else from a remedial standpoint, not much else for Ms. Geyser to do. However, I forget which doctor it was. It may have been Dr. Collins or Dr. Lundbone, did state that what happens in a situation if Ms. Geyser stays at Winnebago is that they reemphasize the therapy that she has and they work more diligently at it. So it's not totally an end of the line type situation. Parties should also keep in mind that it gets lost in the shuffle is that the court doesn't have to accept any professional opinion. It's clear that the court can listen to what takes place, but the court doesn't have to accept their final opinions. I look to the key case, not the key, well, it is a key case. There's a series of cases in Wisconsin involving Randall State versus Randall. Allen, Aiden, Randall. The most recent decision of the case is at 2011 WISAP 102. It's a 2011 decision, but Randall's been around since the mid-70s, 1975, 76. He murdered, the bottom line is he murdered 2 police officers in a really vicious way in the course of a robbery, and ultimately was committed and went through a number of petitions for review. And in, I think, at least in the 2011 case that's been cited, it was his 4th petition for review. There, all of the doctors testified, and the 3 doctors testified in favor of supervised release. The court denied it. So that emphasizes the point that the issue of experts testifying still doesn't change the court's view that the court makes the final decision with regard to what occurs. So I do begin my analysis of the case going to the statute that's been cited, but I want to reemphasize what it says. It's in 971.17 sub 4 sub B. It says the court without a jury shall hear the petition within 30 days after the report of the court appointed examiner is filed with the court. The court shall grant the petition unless it finds by clear and convincing evidence that the person would pose a significant risk of bodily harm to himself or herself or of serious property damage if conditionally released. In making the determination, the court may consider without limitation, because of remuneration, the nature and circumstances of the crime.
Okay, I'm just going to fast forward just a little bit.
And what arrangements are possible. This was referred to in 2 decisions, at least in earlier this year in 2024, but it's still good law. So now let's look at this case. First, the court looks at the what happened, the nature of the offenses. This is it's a brutal murder. There's a brutal attempted murder. And another aspect of the case is that everybody involved, the victim, the 2 assailants are all 12 years old. They're all kids. But Ms. Geyser and Ms. Wire attempt to kill and wanted to kill the victim. The reports show that she was stabbed 19 times in the body torso. And was basically left to bleed to death. It is fortunate that somebody came by and either saw her or heard her pleas and were able to get the authorities there, the fire department, the paramedics, to save her. Otherwise, she would have died. Now, there's a lot that can be said about that type of situation, but you think first of that there's no plan out there. There's nothing been worked out. Now, of course, you see, well, in conditional release, that'll be worked out. But that's a factor the court has to know. Do they have somebody to help support them? Do they have a job they can go to? Do they have a plan for job training? All of that is really left open in this case. Another part of the statute refers to
Elaine, I'm so sorry. So I need to head out, but oh wait a minute. Okay. The judge says it. Okay. Let me try to see if I can do it real quick.
is it significant for the community? At this point, this court satisfied that the credibility issue undermines Ms. Geyser's stay at the institution. That until that credibility issue is resolved, that risk is high. We have two different versions in a way as to why the attempted murders were committed. And, this isn't just an aspect.
Okay. All right. I am comfortable to say that it sounds like he did not go for it and the judge decided to not do it. I hope you all have a great rest of your day. I'm glad to get to cover this. I agree with the judge. I think there needs to be more time and they need to figure out, okay, if you weren't psychotic, then what's going on? And even if she is psychotic, she can be on antipsychotic medications and be stable and possibly be released. And so I hope that is helpful and I hope you all enjoy the rest of your day. Bye.